Okay, the House Committee on State Government will come to order. Clerk, please call the roll.
Representative Sells.
Here.
Representative Bedsole.
Here.
Representative Rogers.
Here.
Dr. Boyd.
Here.
Representative Butler.
Here.
Representative Chestnut.
Present.
Representative Cole.
Here.
Representative Keel. Representative Kirkland.
Here.
Representative Lawrence.
Here.
Representative Paramore.
Here.
Representative Shaw.
Here.
Representative Stahagen. Representative Wood. Representative Yarborough. We have a quorum.
Okay. Thank you, quorum's present. At this time, we'll take up Senate Bill 195, and Vice Chairman Bledsoe will handle it for Senator Butler.
Thank you, Mr. Chairman. Members of the committee, SB 195, this bill would add one House member and one Senate member to the Contract Review Legislative Oversight Committee, which is responsible for reviewing certain state contracts for personal and professional services and private entities. So just this would bring, with a one additional member, 4 in the Senate and 4 in the House.
Okay. Is there any questions, any comments? Okay, Paramore. Do I have a second?
Second.
Okay, do Yarborough. Okay, all in favor say aye. Aye. Any opposed? Okay, thank you. Thank you, Representative Bledsoe.
Thank you, members.
Okay, next up, Chair will call HB 278 by Mr. Representative Pringle, Speaker Pro Tem,
Thank you,
ex-chairman.
Thank you, Mr. Chairman. It's a pleasure to be back at state government. Ladies and gentlemen, House Bill 278 is simply the codification act we have to pass every year to codify everything that we passed last year. This is a record-keeping, housekeeping bill that apparently the pro tem is charged with passing every year, whoever the pro tem may be.
Okay. Okay, all in favor say aye. Any opposed? Okay, thank you, members. Okay, Representative Pringle, we're going to call up now HB 204, which I think is the same legislation, just the Senate version.
SB 204?
SB 204, yes.
Okay. Ladies and gentlemen, this is, again, it's a cleanup bill. It's a typical Representative Pringle bill. It cleans up some ambiguity in the law, and it's kind of does multiple things. One of the things it does is it cleans up, like the Contract Review Committee. I'll just add another person. Contract Review only has to have one person present for it to be a quorum. So it's an interesting committee. But there's a question, you know, legally our term ends at midnight. Yeah.
Okay, is this the same bill as we just done for you?
No, this is this should be the Senate version.
Senate version of the same bill you just to codify the
What's the short title on the Senate bill?
same as your first.
Okay, it's the same. Okay, I've got two bills in front of you. So
Okay,
I'm
okay, just want to make sure.
All right, yeah, this is the same bill, the Senate version.
Okay, same bill as the Senate version. Paramore, second. Okay. All in favor say aye. Aye. Any opposed? Okay, that bill's passed. Okay, now we'll move to HB 372, which is your other bill.
Okay, this is the one I have in front of me. It changes the session date back to the first year of the quadrennium to Tuesday of February instead of Tuesday in March. It just moves it back a month. That way we can go ahead and get started. Uh, Contract review, again, is a committee of one for quorum. But this one, there's a question of whether the contract review committee actually exists in December, January, and February before we have organizational session and people are appointed. And without contract review, you can't technically enter into contracts. And we've just been kind of winging it for years, just saying, well, if you were on the committee and you got reelected, you're automatically still on them. We're codifying it, making sure it's clear. Same thing on finance and budgets. State house property, it gives control of the parking lot to the legislative council and transfers title to legislative council. And in case of the lieutenant governor's vacancy, it clarifies that the president pro tem of the Senate can act on behalf of the lieutenant governor legally and make appointments. We ran into a problem where when Governor Ivey went, does the pro tem actually have the legal authority to make the appointments and truly act on behalf of the lieutenant governor? And this clarifies that. It is just, council to organizational session that we elect our council to an organizational. Just kind of a cleanup bill. That's all it is. I do have an amendment, though.
Okay, do we have any discussion on the bill before we move to the amendment?
A lot of it.
Yes, ma'am.
Oh, am I first?
Yes, ma'am. Recognize
All right,
Representative Boyd.
all right. We gotta be mighty careful, but we gotta look at what's here, even if we got who is here standing in front of us. What are some of the disadvantages of this as it relate to the AG? I'll ask it in another way. Would it give him or her special exemptions to public contract review?
What page are you on, Mr. Boyd?
I'm not on the page. I'm just asking the general questions as they relate to the whole bill in the sense of, I'm asking you, does it give?
You're on page 7, line
81, 80,
Yeah,
I don't have
yeah.
mine in front of me.
contracts for professional services executed by the Attorney General in preparation for or during the litigation may be redacted until the conclusion of the litigation. And ladies and gentlemen, what that is we have expert witnesses the state has hired that have been attacked and threatened and harassed prior to their testimony. Because the contracts have to be signed before they can ever be done. It doesn't keep that person secret because once the discovery is filed in the courts, that person's name will become public. But for the purposes of engaging into the contracts, it allows them to redact the actual person's name and location so they can't be harassed or intimidated.
Okay, I got to follow up. When you deal with the challenges to elections,
Yes, ma'am.
all right, does this bill not put it entirely, if passed, into the hand of the House instead of having the courts to conduct the dispositions and the discovery?
It's always been in the House, but what you're dealing with is a 100-year-old statute, and it's basically what it's saying is the House has the ultimate decision on who's seated in our House. We can throw you out or we can accept you, and it just clarifies and keeps it out of the court because this could be a very political decision, and it could affect a lot of people in this chamber as to where their true residence is and where they actually live. And if you're certified by by your party, then you're certified by the Secretary of State of the state of Alabama, and you were duly seated in our body and sworn in. As far as I'm concerned, that case is closed. You were here, and if there's a problem, the voters will decide at the next election. They'll rectify the problem. But we can't let this continue to drag out in courts.
Did we not have a challenge to one in that sense of where,
Yeah, you can challenge it. You just have to challenge it before the person's seated or before they're certified.
all right. Is this any concerns or do you think it would be within a new state house, and I'm gonna leave you alone and let some of the others, being built, is there any direct correlation and disadvantages or advantage?
To a new state house?
Yes. as it relates to this bill, I'm asking.
Well, I mean, I think the pandemic clearly showed to everybody in the state of Alabama, this building is a piece of garbage. And to keep trying to fix it is like putting lipstick on a dead pig. It does not work. This is one of the few rooms we have where we can actually simulcast our meetings. Most of the meeting rooms cannot be simulcast. And this building was never intended to be used what we're trying to use it for. It's a sick building. I know numerous committee clerks have had multiple surgeries on their sinuses due to the mold infestation in this building. And it's not publicly accessible. It's not ADA compliant. So, I mean, the thought of getting a new building, yes, we need a new building.
I'm
Yeah,
sorry.
yeah.
I'm not knocking the construction of a state house. I'm just talking about the time it's coming and the effects on what this bill is doing. That's my concern.
It is clarifying that the Legislative Council does own and control the property, the parking lot, yes.
Last one, is there a decision presently in the courts that might have some effect on getting this bill passed? And I rest.
Not that I'm aware of, no.
All right.
Mr. Chairman,
And I have an amendment.
Sir?
I have an amendment.
Okay, you want to do the amendment so we can address all of it at one time?
I want the bill to go away if I could. I don't want no amendments on nothing. I want it gone. If I could.
Okay, who wants to talk? Representative Lawrence, Representative Lawrence?
I got my light on right now, Mr. Chairman.
Okay, I don't see your light, but I got you.
okay.
You recognize.
I think you did. Hey, they got to wrap
See there, we need a new state house so I can see the lights.
I'm going to remember when we make office assignments. And parking assignments.
Okay, Representative Rogers, you're recognized.
All right, the question I got, what is the building of a new state house got to do with all the other stuff we added in here?
It's
I mean,
just-
this is big. I mean, I know it's greased. I know it's greased as a whole. It's a greased piece of bacon. I know it's already greased up, but what does it got to do with all the stuff we got in this bill dealing with the Attorney General got redacted stuff like that? Well, last time I saw them redacted when they had the committee here in Washington. Got everything gonna be redacted for the Attorney General. I think the public should know what's going on. So why we got to redact all this stuff for some contractors? What's it got to do with building a new state house?
Well, this is a catch-all cleanup bill. This is kind of a typical Chris Pringle bill that comes in and cleans up stuff that needs to be addressed over a long period of
I'm
time.
not cutting you. But the bill, you start off saying the bill is building about a new state house, and we're gonna do all this stuff about the mold and all that kind of stuff. I agree with that. But then you come in here and start talking about redacting stuff for the Attorney General, and we start redacting stuff. You cut folks off who the public out of knowing what's going on. So you redact it so they don't know what's going on. So why we got to start out about redacting stuff in a hot thing talking about building a new state house? What that got to do with building a new state house?
Well, this does a lot more than that, sir.
Well, it probably does. Tell me what it does. I'm glad to know.
It changes the session date, beginning of after the
Okay,
after the
let's
election.
stop right there. What the Sam Hill that got to do with building a new state house?
It's all part of the same bill.
That's what I'm trying to tell you. Why we going to do a whole greasy hog in one bill?
Because we're trying to clean up a bunch of stuff that needs to be addressed.
All right, go ahead. Go ahead.
Cleans up contract review. The number of members on contract review and how you're appointed and the certain length of your service and term. The Joint Committee on Finance and Budgets, it updates that. It updates the State House property. It updates the Lieutenant Governor's office in case of a vacancy. It updates the Code Commissioner's duties. And it updates the tax expenditure report from biannual to a biannual. And it updates the Legislative Council. And then it also updates the Legislative Committee on Public Accounts. And it updates the Commission on Uniform State Laws.
All right, the question I got: why you got to redact certain things? You got to black out certain things. I mean, we redact so you don't want nobody to know what's going on. That's where redact we start redacting.
We're trying to protect our expert witnesses in different cases from being harassed and intimidated by outside forces. But their names will be made available before the trial when the trial papers are filed. You're not keeping it secret. I mean, you're just holding it back until discovery is made in the trial.
I mean, I'm sure some wise attorney will see this and want to know why they can't see the whole situation.
They can see the whole situation once it goes to court and the petitions are all filed.
Well,
Just before that, when the Attorney General was trying to contract with expert witnesses.
well,
Because I mean, the plaintiffs don't have to disclose their expert witnesses. When we're defending us, we have to disclose them before. We'll all know everything once you get to trial. It gives the plaintiffs an unfair advantage because they don't have to disclose to us who their witnesses are up front.
okay, Mr. Chairman, I have another question. Now, I know when you start redacting, so you hiding something. I mean, to me, if you got to block it out, you got to go through all kinds, jump through all kinds of hoops and barrels to find out what's going on. Somebody hiding something. The other question I got, when Nelson said you're gonna build a new state house, that's fine. We need one. I'm all for that. But why we put all this stuff about the redacted? Then on top of that, they got a hearing going on right now down there somewhere in the state of Alabama. All right. Now, I understand the person could put the hearing on to find out what we do about this. So now, why we got to put ourselves in the middle of the fight in the legislature to decide who should be the winner in the district when it ought to be in the courts? I mean, the lawyer's gonna be there. They got somebody. And one of you guys get in a contest. Y'all, I mean, I know if I was a Republican, yeah, I want y'all to hear. But if I was being honest, I want to go to the courts, but I got a fair shot at winning. So why you want to complicate a case that's already out there right now, still out there right now, pending? I understand the guy said, no, I'm gonna put it off until we pay this bill here and give him upper hand. So why are we gonna throw ourselves in a bill dealing with construction by the State House? Now you're talking about getting involved in election contest. Put it in the hands of the State House. That doesn't make that. I mean, it's too much in this bill. What it looks like to me, Representative Pinkley, is a cover for a whole lot of stuff that you want to get in on the side. I mean, I know it already passed the Senate, and I'm not crazy. I know y'all got it greased up. Is like a piece of bacon. It's so slippery you can't get it down your throat. So now I know where you are, but just explain to me, why would you take a bill like this and just F it up like you went F-ing it up? That's not a good word. You put the U in. I say F. I put the U. I said F, and I ain't put, Tell me that. I try fixing it up. Right? I'm trying F-I-X-I-N-G. That's F-U. Fix it up.
I'm just slippery like that.
Well, I agree with that now. You got me on that one. I agree 1,000% on that one. But just tell me why you do this. Why you take a bill like this, just pile all this stuff?
All this is just clarifying the code. There's nothing secret or hidden agenda in there. It's clarifying the code. And sometimes, you have to update laws that are 125, 130 years old that no longer are applicable in our modern society.
Well, why don't we just come on the bill to redo the state, build a new state house like we did before? We never did come to fruition. And,
well, I mean, you're asking me. I mean, it removes the lieutenant governor. It's what you're looking at is the legislative council. It gives control of the property to the legislative council. It also moves the election of the council to the organizational session. It removes the lieutenant governor as a non-voting member, provides initial meeting shall be called by the president pro tem of the Senate, and clarifies authority to contract for the construction of a new building with RSA or any other appropriate party.
Get to the point about the election contest. That's one I'm concerned about. Election contest. That's the real tapeworm in this thing. The election contest. Tell me about the election contest.
What page are you on, Mr. Rogers?
It's in the courts.
What page are you on, Mr. Rogers? Well, help me find it. So tell me what page you're on.
I think that's on the last page.
It's so much stuff in here, man. I gotta go find me a lawyer to read this one. Y'all got this one really messed up here. Now, don't they have a pending situation already about election contest? Pending.
I'm going to yield to your expertise on that.
Don't we have one pending right now? Do we? Yes, sir. We do have one pending right now. And why we gonna put our little DG hands in when the courts get held?
Somebody help me out. I can't find it.
Is that what you're referencing, Mr. Rogers, on page 29, the bottom, it looks like this is going to repeal code section 29-5A-24.
Yeah, that's it. It's going to repeal it. So then, what it really means is that instead of courts being involved in an election contest, it now falls back to the legislature to make decisions about who the winner of whatever particular district that is, who the winner and who the loser. And when that's a hint of a favoritism there to me, because the guy might know more people involved in that's going to be making decisions than people outside. They'll judge, but judge probably be more fairer. So why we want to get involved in an election contest when we got judges and attorneys who can fight it out in the courts?
Because,
You
I mean, you got to remember, they were duly elected.
What they got to do with building a state house in the first place?
Well, they were duly elected. They were certified by their party, whether they were Republican or Democrat, doesn't matter. They're certified by their party. They're certified by the Secretary of State. They were administered the oath of office, and they were seated in the House chamber. What? I don't understand why you think that's not enough protection.
If it's a contest, why you want to put that in the belly of the legislature?
Because if you can still contest an election, you just have to do it before they're certified. You're not taking that away from you.
But I'm telling you what, when it ought to be heard by the courts, now the decision can be made by us down here. Who gonna be the winner, who the loser in it?
We pick winners and losers every day.
That's what worries me.
Well,
You know, we lose, we pick. So I'm saying, why in a bill you talking about building a state house, you gonna put all this other stuff in there, and the legislative council?
you just picked that one little part of this bill. You just won't get off that one thing. With it.
It's in
And
there.
it's not actually building it.
It's like
just,
Prego, it's
it's
in there.
giving us control of the parking lot is all it's doing.
It's like Prego. It's in there.
All this bill's doing is giving us control of the parking lot legally, and it authorizes the legislative council to begin the process, which is expensive and very burdensome, to figure out where one can be built and what it costs to build it.
Fine. Now, what about getting involved in an election contest? That's the part I'm asking you about.
Yeah,
I mean,
well,
I'm all for the state house. I'm all for the parking lot and all that stuff. It's fine. We need that. But why do we want to take away from the courts the election contest that's going on right now and put it in the hands of the legislature? That's the question I'm asking.
Because
If it's about building a state house, fine.
the issue
Want to get rid
is,
of all this mold in here? That's fine.
yeah,
I ain't
I'm
no
going to say
problem
it
with
one
it.
more time. Duly elected, certified by the party, certified by the Secretary of State as duly elected, sworn into office, and seated in the chamber. I mean, we have the ultimate authority anyway, no matter what the courts rule right now. It does not matter what that court rules. We will make the
On
decision
contested
right now.
elections. On contested elections now,
Yeah,
Alabama.
we will
legislature-
make the decision. It will
We'll
come
make
to
the final
legislative
decision.
council. Legislative council will rule, and then we'll take it to the floor, and the floor will vote, and it'll be settled. It's all
On
it's
the
gonna. We're gonna settle it anyway.
On contested positions for this legislature, we gonna make it take out of the court hand. We gonna make decisions. I want John Doe something.
We already do that.
When we start doing that?
About 100 years ago, when we passed the 1901 Constitution.
It came down on horse and buggy years ago. They had to have 5 months to get down here on the horse and buggy.
You want to say it's bad in the past, but when I try and fix it and bring it to the modern, you're saying it's bad.
Well,
I confuse. You've got me confused now.
Come on, Chris. You think it's fair for us to make decisions? That's
We
in
do
the
it
court?
now. It does not matter what this court rules. It'll come to the legislature, and the legislature will
Tell
vote.
me when is that they had decided who the winner in District 55 or 56? When is they made a decision who won if it's a contest or
House
somebody
is-
did something wrong?
The legislature is the ultimate authority already.
Okay, I think we've discussed that, Mr. Rogers. Anyone else have a question?
Man, this is camouflage.
Okay, Representative Chestnut.
Okay, I just want to look at page 7. See here, it says you're adding contracts for professional services executed by the Attorney General in prep for or during litigation may be redacted. So basically, is this going to be like, so if the Attorney General says, hey, my office doesn't have the resource to pursue this case, we're going to hire these other attorneys and these experts, and so they won't be disclosed?
You have to disclose, as you well know, once it goes to court. When you get to court, that puts the state on the same legal footing as the plaintiffs have. because they don't have to disclose anything until all the paperwork's filed in court. Once the state files their paperwork, everything's public. But what this is designed specifically to do is help our expert witnesses who are being attacked and harassed because their names are in the contracts months before the court and before depositions. But by the time the papers are filed and they start taking depositions, everybody will know who it is. Yeah.
So are you saying that once they contract, that it's posted somewhere? And
Well, the
people are going
contract,
on?
once you're an attorney, when you file your paperwork with the court, who your witnesses are going to be, right? Say you're the plaintiff,
Yeah.
right?
Yeah.
Do you have to tell the defense who you're calling as a professional witness prior to that date?
Yeah, you do
When you
because
file, right?
yeah, you do because you have
When you
to
file,
give
right.
you have to give them an opportunity to depose
Exactly.
that witness. And
Exactly.
so they need to be able to
And that's exactly what's going to happen here.
get their curriculum vitae and everything.
Exactly. And when you get to that point, the name of that expert witness will be given to the plaintiff's lawyer so they can depose him.
But couldn't the court handle that? Because if
The
typically
court-
what
the court
happens
does handle
is
it.
you can request that it that there be like a that the attorneys they share the information, but it doesn't go beyond to any third parties. I mean, that's an easy fix without having to put it in the law. It's almost like it looks like you're trying to give the AG some kind of authority that you're not giving other agencies, and so it's creating a
No, it's not. You have two private entities.
Mhm.
You're suing this company, and this company has their lawyers, right? When do you disclose to the company you're suing who your expert witnesses is going to be? When you
Rule
get to court.
26 disclosure, you have to
Exactly.
do that in Rule 20 at that stage. So,
Bingo. And when does that occur? When you file your motion, who you're going to call for an expert witness.
yeah,
That's when the
pretrial
defense attorney knows who you're going to call, right?
But
All right.
you have to, but it's mutual though.
Exactly.
I mean, right?
It's perfect.
I mean, because one has to do it first in order for you to be able to. You might have to go find your witness to
Exactly.
combat
Exactly.
that person's expert witness.
Yeah.
Once you've
Exactly.
viewed his.
All right. And here's the problem with the state.
Mhm.
The state has to go out months prior to that and contract with their expert witness, and it goes through contract review. So it's a public contract. So the plaintiffs know for weeks and months who our expert witness is going to be. So their people go out and start harassing them and trying to intimidate them. All this says is until the point where they get to the courtroom and the court makes them disclose, that name can be held. And that way, the plaintiffs and the defendants find out who the expert witnesses are at the same time. It levels the playing field for both sides of the case. It's all about fairness.
Any more comments, questions?
I'm still. I still have because this. I have this comment. This is like 5 bills in one. Did you ever think about breaking it down into separate bills? Because it seems like you've got different ideas going on, and it's clustered into a 29 or 30 page bill. And so, and as a lawyer, as I'm reading it, it's hard for me to follow it because I read one page and it's talking about the structure. And then I'll read another page and it's talking about contracts. And I'll read another page and it's talking about elections. And I'm trying to figure out, like, why is it all, is it by design or what? Because it's hard for me to follow. And I went to school for this. So, I mean,
Let's bring up the amendment so maybe that'll help us with something that we're talking about. So if you would go ahead and introduce your first amendment. Okay, and if you would, give us the number of the amendment up in the top left corner so we know we're on the right amendment since you have two. The GP and the I-8.
Okay. I'm gonna do GPQ
Okay,
EC2-1. And this is this is amendment clarifying the parking lot. The property. That will be deeded to Legislative Council.
Okay, any questions on that? It's just a legal description of some property.
This is all about,
Yes, sir.
this is all about parking and all that stuff around it.
This is a description of the parking lot.
Well, that's fine,
Property.
because it goes with the bill, should be about rebuilding a new state house. That makes sense.
See?
And this part of it makes a little sense. It's right on point I see, and it makes sense. So go ahead.
Okay, do we have a motion to accept the First Amendment? Second, Perry. Okay, all in favor for the First Amendment, say aye.
Aye.
Any opposed? Okay, how we gonna move on to the Second Amendment?
This amendment simply, in this bill, we're clearing up the duties of the President Pro Tem of the Senate in case of the vacancy, the Lieutenant Governor giving the Pro Tem the power to act as Lieutenant Governor in case there's a vacancy. This puts something near and dear to my heart. The Speaker Pro Tem of the House will, in the case of a vacancy in the Speaker's office, the Pro Tem really does not even exist in the statute. It's really only a rule. And the only thing that, in the early 1900s, there was a legal challenge to the person acting as Pro Tem signed a bill. And the courts ruled that no, he was legally able to sign the bill as a Pro Tem. And what this does is says, in case we unfortunately lose a speaker again, and we're not in session in order to elect a new Pro Tem, that the existing Pro Tem can act as a speaker until such time as another speaker is elected. It gives them, because the speaker makes a tremendous number of appointments and has a lot of obligations to sign all kinds of legal documents on behalf of the state. And this just said, it's kind of a line of succession in case we lose a speaker. That's all it does.
Okay, thank you for that explanation. Yes, sir, Mr. Rogers.
In other words, it means that if per chance the speaker gets sick and die, the Pro Tem automatically assume his position. That's what it really says, right?
Yeah, until such time as a new speaker is elected, yes.
All right. But okay, I'm gonna let it slide. But suppose we want another speaker in case speaker dies.
I said it.
That'll be left in the hands of the legislative side. Well, we want to keep the Pro Tem. We want a new speaker.
You have the right to move to elect a new speaker at any time.
But you say
But we have to be in session. I mean, think about this. What happens if we get out June 20th and God forbid something happens to our speaker on his way home from that sine die night? If we don't go back into session until January, we can't call ourselves into session. So whoever the Pro Tem would have to act as speaker until such time as the body convenes as a whole in order to elect a new speaker. And being a part-time legislature, I mean, the speaker has a tremendous amount of responsibility. I didn't realize how much responsibility the speaker had.
How we do it right now?
We've been very lucky right now because
Yeah, but we don't have anything, any provision in place now in case the speaker passes to replace him with right now.
exactly
Right now.
That's the reason for this.
For 100-something years, we've been
We've been lucky.
200 years, we've been operating without any provision whatsoever. I'm looking at my man in the back there. He wouldn't know. Is that right? We never had anything in place to do a thing about the speaker passing.
Right. Well, if that's the case, this law will never affect anything.
Yeah, exactly. See, that's what I'm doing. I'm just finding all these problems and trying to plug them up and fix them and make sure we're covered on multiple fronts.
This is 100 bills in one. This is what you call a catch-all bill.
Yeah, I know. Arthur and I came up with this bill.
Who came with
Arthur Latham.
Okay, thank you, Representative Pro Tem Pringle. Do we have a motion?
I want a roll call vote on that, man. On that, man. I got to check out and make sure that that don't sound right that we, for 100 years or 200 years, we operate with not in the process.
Okay, hold on.
I'm looking, my expert back in the back. Can he address this, please, Mr. Chairman? You got an expert back on this in the back. I would like him to answer this question. Yeah. We have not had anything in place over 100, 200 years in case the speaker passes to have a replacement for him.
Right.
Nothing official, but we just been doing about happenstance. Yeah.
That's right. So, Mr. Rogers, if this law was in place, it would have never affected anything. If in case if there's no vacant seat, then nothing would ever happen. Okay. Okay, Representative Chestnut.
Yeah, so I was, we just had that conversation. I went and looked up section 17-1653, and it talks about the one that you're repealing, and it specifically states that you're supposed to have a presentation of the question to the House, right? So this is not anywhere in the Constitution that says that the House has to hold a trial on an election challenge, right?
We must.
It's not in the Constitution, right?
No, it's a statute.
It's
100-something-year-old
legislatively
statute.
created,
Yeah,
right? It's
yeah.
a legislative
Yeah.
manufacturing, so to speak. So
What page are you on, Mr. Chestnut?
29, the section 2, the
Yeah.
part that's been repealed. And see, it references, you see that section 17-16-50 through 17-16-53. I just looked up 53 on there, and it
Section 2, 29, 5A 24.